We'll just start with some introductions around the table. So those of you who've been here already, I think you can just sort of say, hi, I'm so-and-so. But for the others, we'd love to hear what brings you here and why this is important to you to be here today. Jill.
Oh, thank you. Well, my name is Jill Clayton. I am the Information and Privacy Commissioner for Alberta, and I am a new fish in the fishbowl. I think, like many others who are here today, I was certainly emotionally affected by the stories that appeared in the Edmonton Journal and the Calgary Herald last December. Obviously, those are very devastating, tragic, very, very sad stories. I feel very fortunate to be part of the what is a very important discussion that is taking place as we talk about how we can do things better and what needs to be changed. I'm here to learn more about the issues, certainly to hear from experts, but probably most importantly to hear from those who have lived experience. Hopefully, I will better understand the issues and identify ways that I and my colleagues at the Office of the Information and Privacy Commissioner can contribute to improvements in the system.
My name is John Archer. I'm the president of the Alberta Legislature Press Gallery, representing journalists who mostly work out of the legislature, but on a frequent basis report on provincial politics in Alberta. I've been a reporter with the CBC for 20 years, almost 15 years of which has been spent in Edmonton. I've been a legislature reporter for 9 years, and I've been the president of the gallery for roughly 4 years. And I'm here to represent the interests and the thoughts of members of the gallery.
Okay. I'm Dr. Anne Sauvageau. I'm the Chief Medical Examiner of Alberta, but I'm a stale fish.
Good morning, Eric Wazelenko. I'm a clinical ethicist and a palliative care physician. Thanks.
Good morning. I'm Colleen Wilson with the Alberta Press Council, and I'd like to thank you for inviting me and greet Mr. Moderator, ministers and MLAs present, ladies and gentlemen, and those citizens that are watching us on the web. It's an opportunity and a privilege to represent the Alberta Press Council and to be part of this roundtable. And I also want to thank the many journalists that helped me with my research. I am not a journalist, and it was very important that I connect with them to get their feelings and their stories, as well as the Edmonton Journal and Calgary Herald, who actually printed information that now we're sitting here because of. The Alberta Press Council has a mandate, and it is to receive and mediate from the public and adjudicate, if necessary, complaints on our print media that are members of ours, to defend the established freedoms of the press, and in certain circumstances, to speak out against limitations on access to information. There are 3 industry members and 3 directors who are public members, and the chair is elected from those public members. Right now, our current membership includes the Red Deer Advocate, Lethbridge Herald, Medicinet News, and the 121 weekly newspapers that are members of the Alberta Weekly Newspaper Association. And we are independent of government. So do you want me to continue with this 2-minute thing? It's come back. Okay, thank you very much. On a personal note, though, I'd like to mention that our family has had the privilege of raising my great niece, who we picked up off the street and was going to be put into care, and is an FASD client. I'm happy to say that our family decided to take her. My youngest daughter did that, and she's now living on her own, has help, has a mentor from PDD, has had a job for 3.5 years. She was 18 months old then, she's 21 now, and it has been a real journey to get to know some of the families who struggle with these things without the assistance that's out there for them, and it's heartbreaking. Thank you.
Hello, my name is Samantha. I've been invited to this roundtable by the Office of the Child and Youth Advocate. I am a young person who has received services from Child and Family Services. I'm 21 years old now, and I have my own little daughter. I'm now living independently, and I'm in my second year of the social work diploma program at Grant MacEwan.
Hi, my name is Faven, and I was also invited by the Child and Youth Advocate's Office, and it's a great honor to be here. I am still in the system, and when I was told about the issues and I read about them, it was something that I was very honored to be a part of and give my perspective. Yeah, it's great to be here and to hear everyone's perspective and opinions and what's going on and what you guys are going to be doing to fix the issues. So, yeah.
And I'm Del Graff, Child and Youth Advocate. It's wonderful to have these young people here. Thank you.
Hi, my name is Monique. I am 20 years old. I was invited by the Child and Youth Advocates to speak on behalf of children and youth in services. I'm very honored to be a part of this, and I look forward to hearing about everybody else. Thank you.
Hello, it's Gord Phaneuf. I'm the CEO of the Child Welfare League of Canada, and I look forward to this discussion. I think it's an important one, and I think it's really important that the young people are participating, so I really applaud that. Thank you.
Hi, I'm Ada Bennett. I'm Deputy Medical Officer of Health with Alberta Health, and I feel very privileged to be here. Part of our mandate is to protect and prevent diseases and injury, and that's why I think that this is quite a good place to be. Thank you.
Fantastic. So the question we'd like to debate now is a two-part question. What information should be available about the death or serious injury of all children and the death or serious of injury to a child receiving child intervention services? And then what changes should we consider to the publication ban as we deal with this situation? So Jill, we'll ask you to give us your thoughts first.
Okay, thank you. Well, again, I think that, well, I'd just like to reiterate again that I feel very fortunate to be invited to participate in this discussion. Obviously, the issues and the problems that are being talked about yesterday and today have very real consequences for real people, and I think that it's sometimes easy to forget that when we get all caught up in what we can and can't do. As Information and Privacy Commissioner, I am independent of the Government of Alberta, and I'm responsible for ensuring compliance with 3 access and privacy laws. So we have legislation in the public sector, the private sector, and the health sector. And I thought that I would open by just stating that these laws are based on fundamental internationally recognized broad principles, as are access and privacy laws around the world. And those principles include things like consent, and consent is about giving individuals control over their own information so they can make the decision about who has access to that information and who's going to have it and how it's going to be collected and used and shared. Another fundamental principle is around transparency or notice. So you can't make those decisions about what happens to your personal information unless you understand why it's being collected, how it's going to be used, and who's going to have access to it. Other principles include using the least amount of information at the highest degree of anonymity possible. That's explicit in some of our legislation, like our health legislation. And of course, a right of access to your own information. So all 3 of our laws and other laws around the world provide individuals with a right to access their own information. It's about you, subject only to some exceptions. On the accountability side, so remember I'm the Information and Privacy Commissioner and have oversight for freedom of information legislation. Some of the principles there are that, of course, you can make formal requests for access under the legislation, but in my ideal world, a formal request for access is an exception. It's not the rule. Access to information is should be, you have the right to access the information. There are sometimes exceptions to obtaining information. That could include personal privacy, but those exceptions should be limited and they should be specific. And of course, the spirit of access to information legislation to me, requires that we identify opportunities to proactively disclose information. Being mindful of privacy issues, of course, but to disclose information in a meaningful way, routinely and regularly to release information. So, of course, these are guiding principles when it comes time to apply these principles to situations that are complex, that involve a lot of different parties that bring different perspectives and competing values and different personal experiences. Of course, it's difficult to be black and white, and the legislation is not designed to be black and white. The legislation is designed to balance the specific circumstances and the specific factors in cases that arise. So, of course, I'm also aware that in some cases information may not be shared when it should be, or released publicly when it can be, and often that arises out of uncertainty and fear. So I'm here today. I'm recognizing that there are always opportunities to improve our laws. They are complex and convoluted. We've got 3 laws. They're not necessarily harmonized with each other. So, I'm certainly advocating a thoughtful approach. Take a look at the laws and identify opportunities for reform and harmonization. Where there are gaps, we need to fix them. Where there's confusion, I think there's a real opportunity to to clarify and to simplify. And certainly where there's a need to educate and inform, we need to make that a priority. Thank you.
At the Office of the Chief Medical Examiner, one of the challenges that the frontline worker often see is that people think often that with death ends the right to privacy. And part of our role is sometimes to be the advocate of the dead people and to remind everyone that with death do not end the right to privacy. And that's not just for children, that's for adults as well. You have a right of privacy even once you're dead. And there's people that can represent you for that right, but it didn't end because you're dead. Another point that is very important, I think there's need to be transparency and accountability, and that's what we've been saying for 2 days. And I think there's need to be mandatory reporting of the investigation that are done, that if we were to have a child death review committee, of the work of that committee. But that what is more important is not that the person that died was named Joe Brown. What is very important is to know how many kids died, in which context, what can we do from that for preventing future death in every category, what were the category of age, what was the background on their socioeconomic status, or there's a lot of things you can do by regrouping cases together. If a case is very unique, you can do a lot of things also without revealing a name and an age. So when it comes from prevention mandate, which is more the lens that at the office we think is important, from this lens, the name is not the important factor. And I think we have to keep that in mind, that accountability and transparency can be achieved without going against the right of privacy that didn't cease with death.
Fellow panel members, and all that have joined us here today and online. On behalf of my colleagues with the Alberta Legislature Press Gallery, we appreciate the opportunity to participate in this roundtable. The issues being discussed here today are important not just to the members of the gallery I represent, but also to Albertans as a whole. While I represent journalists and columnists, radio, television, news, and newspaper reporters, newsletter writers, and online journalists, we all serve the public. And our service to the public is something my colleagues and I take very seriously. In fact, it's our duty, a duty to act in the public interest. And let's be quite clear, the public is very interested in the welfare of children in this province, the need to support them when there is trouble, and the responsibility to make sure there are valuable lessons that are learned when things go wrong. I've spoken with many of my colleagues over the past few days in order to prepare for this roundtable. My comments here today are a collaboration of their thoughts and observations. Our biggest concern is the sweeping publication ban that prohibits identifying a child after death. Names can't be used. Photographs are prohibited from being published or broadcast. Because of this, the government doesn't release information about deaths of children known to the ministry. They're kept secret. Scrutiny doesn't happen, at least the kind of scrutiny that Albertans expect. The colleagues I represent are resolute on this. Disclosure should be the rule, secrecy the exception. And in each case, when secrecy is believed to be necessary, it must be justified. Right now, the system under which we operate is the exact opposite. Some are suspicious of the media's motives in wanting this change. Let me share a couple of viewpoints on that. This isn't about morbidly wanting to do stories about dead children. There is no commercial value for the media who seek this information. This is about wanting to improve the system and the overall well-being of Alberta's children. If we, as journalists, can't make these cases real for people by using their names and their pictures, the issue isn't properly shared with the public. The stories of these children are not memorable, and Albertans are not served in a way that they need to be. We want what's reasonable. We want what our colleagues in practically every other province in this country have the ability to do: inform the public. Those other provinces afford that right to journalists, and their child welfare systems have not collapsed. Some might argue we already inform to appropriate standards. There are plenty of stories you have either read about or seen on television that use fake first names or initials. As was pointed out by a provincial court judge at a fatality hearing 7 years ago, the use of initials dehumanizes the tragic death of a young person. Which is another point my colleagues stress. These are our most vulnerable members of society. They have no political power when they are alive, and they are marginalized socially and economically. Requiring that they remain anonymous after death takes away the only power that they have, the power to potentially lead to change in practices that could save another young life. As was stated to me, keeping their names hidden is the final humiliation. Let me quickly share with you some short descriptions of a few of the colleagues I'm speaking for today. Some of the ramifications of the system we have now and its lack of disclosure and transparency. One of my colleagues was at home on vacation one day. He went to the door to see who was there and was greeted by a police officer who handed him a summons to appear in court. He was accused of breaking the law because he had done a story about a victim of a horrific crime, and he said her name. He did his job. Another of my colleagues has been called a racist on more than one occasion. She's been called this because of the number of stories she has written about the shocking number of Aboriginal children that have died after the province decided intervention was needed. She did her job. And another of my colleagues has baby pictures covering the walls of her office. She's not a mom. The pictures are of dead children that she has done stories about. She can't show these pictures to the general public because that would be breaking the law. She does her job to the best of her ability, but she is constrained by the laws in this province. I don't tell you about my colleagues like this because we want your sympathy. The things we have to deal with don't come anywhere close to the tragic circumstances families go through when something has gone wrong and an intervention wasn't handled properly, or an intervention didn't happen when it should have. I tell you about my colleagues so that you have an appreciation for our commitment to our jobs. Our commitment to push for a better way of doing things, a system that is transparent without being overly intrusive. This is what we firmly believe is in the public interest, and that is what this roundtable is supposed to be about. Earlier this morning, we heard the Premier speak, and I took a couple of notes about how we need to change the child welfare system. We can't use the same old models, and child welfare needs to look different than it does today. Obviously, these comments were only made this morning, so I haven't had a chance to survey the members of my gallery, but without going too far out on a limb, I would say we concur. I look forward to sharing many other views with you that my colleagues have shared with me.
And the balance of potentially competing values, beliefs, and duties. My call is to make sure that we've got the principles right. So we've heard this morning, and we read in our binder literature, that Alberta Human Services is trying to balance the need to protect the privacy of vulnerable people with our responsibility to be open and accountable about the work we do and how we do it. I think that's really laudable, and I think that's correct. But it may not be far enough. We might also need to balance the privacy of vulnerable people with our need as a society to learn and access community wisdom. We also may need to balance the components of dignity for these people. Dignity is about privacy, but it's also about voice, about legacy, about personhood. How do we best understand personal dignity? Again, we access community wisdom. Today is a start. There are many, many more people to ask.
Thank you. I want to begin by being appreciative of Minister Buhler's comments on the CBC program as it happens on Monday evening, and again yesterday when he addressed the group. His comments about transparency, consistently sharing information with the public, and making more data available was music to our ears. This comes down to the value of reporting. Some questions. So what is the process? How does transparency occur? How do you keep the public informed? Who are the ones allowed to have access to information, and is it in the public interest? It is important to realize that media has an obligation to inform their readers how to better cope with issues. How can readers avoid a similar incident or the death of a child? What caused the incident or death? The purpose of the print media is to educate and inform their readers, the public. Any information must be timely and fulsome. The government must be held accountable. Today, social media is rampant. The game of telephone technology is this: in 15 minutes or less, 5,000 people can read all about it. Is the information correct? Has the tweet or Facebook grown legs? And is it misinformation or just hearsay? Official print media is there to dispel myths and rumors. Daily newspapers can be quick to report the facts if given them. Weekly newspapers, if their print cycle is in a few days after the press release or news, can follow up on that story. In all instances, their public will be reading the facts as printed in their local newspaper. Dealing with the law as it stands now, an editor receives information such as AJL on such and such a date was found unresponsive in his crib, or FC on such and such a date sustained a fatal head injury. No information as to where or why. So why is a deceased child not named? Are children protected more when dead than when they are alive? Is FOIP, which protects the living, also meant to protect the deceased, and why? Partnering with official media does not have to be adversarial. There has to be improvement in the practice of sharing factual information on a consistent basis. This is essential. This is also called government accountability. There needs to be a way to enable media to collect factual data, to support an investigation, to educate, to help prevent occurrences, and, yes, to write stories about successes within the ministry. So if you want transparency, legislation and privacy rules have to be changed and a balance achieved. Collaboration and trust between the parties needs to occur. Applying to the court is very costly and takes sometimes years. How open and transparent do you want the system to be? What information should be shared with the public regarding the death or serious injury of a child in Alberta? Not just those children in care, but all children living in Alberta. Who is best to make that decision, and when should that information be shared? Does the public have the right to know? Are there principles and values we should be shooting for? What drives the decision around information sharing? A publication ban as currently written is very prohibitive towards the media. Let's change that legislation so there's more transparency and less secrecy on what, where, why, and how. Don't be afraid of the press. Determine together a process to improve transparency surrounding publication. And let's not forget the families of these children. They want to share their stories. It is their way to honor their deceased child. Right now, the restrictive law silences them. And let's also not rob the public's right to know. Thank you.
I believe that the protection of vulnerable populations is incredibly important, but I also believe that individuals have the right to both anonymity and self-determination. It is imperative that we uphold privacy, but we also promote transparency. We need to ensure that the privacy policy is serving the purpose of protection for the right reasons. It is not necessary to be exploitive towards children and families of children who have died in care, but it is necessary to disclose failures of the system to protect children. It should not be covered up. Gaps in services will fail to be improved until we bring these issues to the face of the public. Banning identifying information in the media leads to erasing the identity and the valuable story of an individual, a human being who has been failed by the system that serves to protect them. Human rights and ethics should be upheld, but tragic stories should not be silenced. I think it's important to look at other provinces in Canada and their policies on publication bans. BC, Manitoba, Saskatchewan, I believe all those places leave it up to the parents to decide what is shared in the media. And I think it's important for parents to be able to share their story. I think it's also important that we look at the benefits and maybe some of the cons that those provinces have regarding their policies. And maybe we can find something that works better for Alberta, because as it stands right now, it's questionable that some of these stories are covered up, that there's a lack of clarity as to what's happening, and I think that there's many problems that could be addressed. We have one of the highest rates of family violence in our province. It's understandable we have quite a few social problems here. That contributes to families and parents struggling to raise a child on their own. This leads to children going into care, and sometimes, unfortunately, they are failed when they go into care and they pass away. And for a parent to be silenced and not be able to share that story is awful. And I think that they brought their child into this world, and in most cases, they should have the right to be able to share their story.
A childish question that popped in my head when I heard about this is there a reason why the children in care are unidentified? Are they any less important than the children who are not? One thing that was brought up earlier is that the children themselves should give permission to whoever wants to release, whoever they want the information to be available to, and that's important. But I believe that there shouldn't be a limitation to the information available of how, when, why the child is dead. The reason for this is because we want to know the reasons, if it could, if it could have been prevented. And I don't think that there should be a difference in the way that investigations take place between a child who's in care and a child who's not. This might be a childish way of looking at it, but that's just how I see it. There's no reason why the children in care should be seen as invisible. That's just how I see it. Is there a reason why they're seen as I don't know, maybe this is just my point of view, but I feel like if we don't investigate and find out the hows, the whens, the whys, and the who's, who the children are, then we're just pretty much saying they were invisible, they never existed, so we don't have to talk about them and we don't have to mention their names. But I don't know, I don't know what to say, but I don't think that there's any reason for secrecy once they're gone. I believe that their life should be talked about and the reason why they're gone, so that in case there's any youth or any children who are going through the same things, who might, because suicide is one of them, right? Who might actually end their life, knowing about this story and knowing that people actually care might prevent it. But another issue is that some kids in care don't want their family to know the information. Like, they don't want their family to have the right to give the information out because they don't believe that they have earned that privilege of knowing about their life and so on. So that's another way of looking at it. That's one thing that we should keep in mind, is that maybe the kids don't want their family to talk about them. Maybe the kids don't want anything to do with their family. So if the family didn't have the right to be a part of their life, then why should they have the right to talk about them once they're dead? That's one thing to keep in mind, and it's a different perspective of looking at it. But there are many things that we need to look at when we go and make decisions about the information that's given out. But the main thing is there's no difference between a child in care and a child who's not. So the investigation should take place in the same manner.
Thank you. One of the things that's clear to me is that this is a complex issue, and one where there are a whole range of viewpoints, and I'm very pleased to start to hear about where those viewpoints converge and where they differ. One of the things that for me is a central consideration is that you know, when we talk about the duty to the public to report, and then there's a view that I hold that say, well, we need to be able to safeguard the rights, interests, and viewpoints of young people. And so how do you then make decisions about those two views when they conflict? There's certainly lots of examples of where you know, information is conveyed, and it can be hurtful to siblings. It can be hurtful to other people connected to a family, and so that there needs to be some balance in those views. And I go to your point about what are the principles by which these decisions are made. You know, one of the things that is, I think, a fundamental kind of view of most of society is that families should get to make decisions about what happens in terms of their children and of their information, and that they play a central role in this. And you know, what does it mean for a family if there's no consideration for what they want? What does it mean when, you know, a child is from a community that feels some sense of responsibility and has a differing belief than either the press or others around the privacy of information? And then we start to hear about those concerns that are related to young people themselves. You know, often I hear about young people feeling invisible as part of the system. And does that invisibility extend into the time period after they die? That's a serious question. You raised the question of should children in care be treated any differently in terms of their rights to privacy and their rights to have their story told than any other child. For me, those are central kind of areas of dialogue that make the situation complex. And I would be saying that whatever kind of decisions get made, children's interests should be at the center of them, that they shouldn't be a secondary consideration. And whether it's families who are making a decision to publicize the experience of their child, whether it's the press making a decision to do that, then we have government who has this legislation. And you know, when I think about children and families and the press, and then I think about government, I think the least significant of those interests should be government's interests, and that children come first in that hierarchy of principles, and government comes last. And so, in that context, I think the dialogue has to take place, and it's a very complex context, and that's what I try to raise. And I try to raise the notion that the interests of children should be first. Thank you.
Thank you. Faven definitely brought up some really good points for both the child and the parent's view. From my beliefs and from my experience in care, we are placed in care, whether it is a child and or youth, whether it is a foster home or a group home. We as youth are placed in the system to have that loving family and have every right that a normal child has that is not in care. So why is it that when a child or youth is passed away, that they have all those rights taken away, not only as the youth, but as the family that is theirs or friends? And there is definitely that point that if that family or that child does not want that family or friends to know that they were maybe in the system or do not want anything to do with the care, then of course that is something to take into account. But as that foster parent or that group home provider or the parent themselves, if we want to prevent these deaths, how are we supposed to prevent them if there's no investigation to follow up, right? If we don't know what caused the death, if the public does not know, then how are we supposed to fix that problem or prevent that in the future? And like Samantha said as well, if there are children or youth, whether in the system or not, who are questioning their lives, and it is publicized that another child has just ended their life because of whatever reason, maybe that youth or child may back away from that decision and not end their life, and that is even just one life that is saved, and every life counts. So whether there's a child or youth in care or not in care, we are supposed to all be equal. A lot of children and youth in care do not have the right to speak up for themselves, or they do not know that they have that right. So I think every child and youth should know that they have that right, and that after they've passed, they should still have that right for people to know who they were, what caused their death, as well as for the families to know. Thank you.
I thought this would be a complex conversation, and it certainly is, which maybe recommends that more thought needs to be given to these matters in a very in-depth way. And I'm encouraged that there's an ethicist in the circle, because there are some strong moral considerations to all of this, as well as the legal and the customary practice issues. I wanted to put something on the table. I appreciated the Privacy Commissioner's reflections on the international instruments that are come into play when we talk about privacy and the right to information. And I'd like to put a couple others on the table that govern us in the work we do in this area. And that's one that's been codified across Canada since day one, which is the best interest of the child. A principle that's entrenched in law, entrenched in international practice, and also the Convention on the Rights of the Child. And the spirit of that convention, which Canada is a signatory to and a proud promoter of, and the protocols underneath that convention. And those need to be interpreting mechanisms for the conversation as well, because they're key to not only respecting the rights of children, but ensuring children have a very powerful voice in their own matters. I say this carefully because I think I can very quickly get out of my depth, but I'm not sure the casting of the question is correct. But if we accept how it's casted, between a balance between privacy and the right to information, then I would definitely say what needs to be added to that is the concern around privacy and the best interest of the child. That's not a secondary principle. It's not a derivative principle. It's a primary principle, and that's not an opinion, that's a statement of fact. So we're here with that principle in mind. We haven't cited it that often in our discussions over the 2 days, but we need to remember that's not just the spirit of the act, that's the spirit of the work we do, and it's the spirit of our collaborating systems and disciplines. So let's keep that in mind. That's not to denigrate other principles, but the best interests of the child, that precept is one that defines us as a caring society, and we can't compromise that. Just a couple of thoughts. I'm not convinced that the issues of accountability and transparency can't be respected without access to the identifying information that's being requested. It bears more examination, but I'm certainly not convinced of that at this point. And I really share the Chief Medical Examiner's view. The overall approach here one hopes as we build a better society where protecting children is in fact our key concern, is we need the press to have access to information. We need the press to have unfettered avenues to everything that they require. And we're going to improve our systems when we have a full debate and we have the information, the data, the knowledge on the tables. That's, I would take nothing away from that. But the story has to be what went wrong. What are the failures? What are the missteps? What are the mistakes? And I'm not convinced that when we get caught up in the identifying information that we're actually contributing to that understanding. And there is a fundamental question to ask, is who benefits with that? You know, is that really the core part of any given story, or are we actually trying to find out what went wrong? And when we talk about the principles of accountability and transparency, I'm not sure those are being cited the right way when it comes to the issue of identifying information. I think when we're talking about accountability, we're talking about the provision of government services, and are they being used the right way, and are we going the right direction, and do we have the right mechanisms for measuring things and the right metric? I'm just a little worried that the issue around identifying information might just take our focus just a little bit off the systems-based issues that we need to look at, like where the problems are and where things didn't go as they were supposed to. Thanks.
Thank you. Gosh, what a complex topic. Just listening to what other people have been saying, it's dawned on me that this is not a topic that has a simple solution. Because, for example, we talk about transparency, and it's difficult to see how transparency and privacy cannot be balanced. I mean, you can be transparent without revealing absolutely everything there is to reveal, but keeping to what is essential for what we're trying to achieve. I mean, for example, if you take the medical history of the child, there are some things that are totally not helpful to the exercise that are there in the notes. And so do you need to reveal that? Same thing, I'm looking at the identity of the child. What added value does it give to what we're talking about, which is making sure that we do the best by our children? And then I look at the other point of view. Families and communities and the rest cope with the situation in different ways. So let's say a child has been seriously injured or has passed. So for some people, having it all out there is a form of healing. So it helps them sort of take it in and move on from it. But for other families, it's a complete intrusion. And for them, it's terrible, you know, the press outside their door and, you know, all those kind of things. We need to consider that it's going to be different in different circumstances. So it's worth thinking about that how are we helping this situation? So let's say it's an injury and the child survived. How are we helping the situation by having their name everywhere? So they go to school and everybody knows this is what's happened. Especially if for that particular child, it's not a healing process. Especially for that particular child, it's a traumatic process. So it's just worth considering. But what I think would really not help is to have a blanket ban on everything. I think that opportunity to say, if it's a helpful thing for this particular situation, yeah, but putting that caveat saying you need to look at each one separately. Because for some situations, it's absolutely the wrong thing to do to reveal information that will identify the people concerned. And it's worth thinking about that. And I really can't see how not revealing that little point about, you know, John Smith was the person involved would necessarily change what would really need to be done in this circumstance, which is look at the system, what went wrong, how that family was supported from before the child was born to when the event or incident happened. That's really what we need to be looking at. All those services, what the community was like and all. And the actual name and address and what the child looked like, to me, it's a bit like those bits of the medical record. You know, I'm coming at it from a physician point of view. In clinical days, a patient comes in, sits down in front of me. you have access to all the notes, but do you really need all the notes to make a diagnosis? So you pick what you need, and then you close the rest of it because it's not relevant to what you're talking about today, and that's how I see it.
Thank you. So we're going to throw it open for discussion. If someone in the audience has something they'd like to contribute, Charlie's your man, and he will come around with the microphone, and we'll see how well we can balance the entire room while still having our people up here on the podium talk as well. So would any one of you, to start, like to comment on something that you've heard so far? Yeah. Colleen?
I would just like to comment on two things of the youth that you have said and then ask you a question. First, I want to comment that the investigation will still take place. It's a different question, and it will always take place. It's a different thing. And I feel for your concerns when you were saying that sometimes the family, maybe they didn't deserve in certain case, at least it's how the youth might feel, that the family didn't deserve the cause and manner of death. I have to say that in the current law, actually, they will have, it's also a different question. If they call the office, they have the right, because they are next of kin, even if they were not having the care of the children anymore, they will have the right to the cause and manner of death. So these are 2 points that are different and that are very clear in the law already. But I would like to ask you a question, because when I thought of it, but I have never been in care, I come from a different perspective. When I see this, I would want you, children in care, to have the same right I do as someone that was not in care, to have my privacy protected. But I seem to have heard the opposite, that you would like the right to have your name there. And I would like to know, if you were to die, and I'm sorry if I ask the question this way, but I'm always in death, so for me, I hope you don't find the question offensive, because it's really not the point. If you were to die, would you like to be a front page case? Or do you think would you prefer that your story is used to improve the system without having every details of your life and your name on the page? I really want to hear that part, how you feel about it.
I was a high-risk youth. If something would have happened to me, I would have wanted my family to heal in the way that they felt would heal them best. I don't think that identifying me would take away from my story, because many youth who are not in care are identified, and just because their name and identifying information is stated, it doesn't take away from what happened to them and their story. Personally, I don't think. However, I also feel that this could be really dangerous. I mean, people really could be exploited. You know, we don't want to further re-traumatize people. I have a personal story that I'd like to share. As a young mother, I struggled as a single parent to raise my daughter. She had some health problems around eating formula. She was a healthy baby. I mean, she's a really healthy girl now. Basically, she was reacting to regular formula, so we tried putting her on soy milk formula. She was reacting to that, so I then needed to put her on a hypoallergenic formula that was very, very hard to find. I had to go to like several different stores to purchase it. You know, it was very expensive. It was difficult. So I was doing the best I could. I was accessing every support that was available to me. And she began to fail to thrive. And I was told that if I couldn't fix it, that she would be removed from my care. My question was, what can you do better than me? If you remove her from my care, she's going to miss me, she's going to become upset. Is she really going to become healthier? Of course, that never happened. She started thriving again, and she was growing, and she's super healthy now. She's up to like here on me when I'm standing up. I mean, she's a big girl now, so no issues there. However, worst case scenario, if she was removed from my care and if she would have died, which I think is hugely possible, if I was silenced, I would not know what to do with myself. I don't think it's fair, just, or right, and I also don't think that anybody else has the right to decide whether or not my story is shared or her story is shared. I think that should be up to the parent. I don't think anybody needs to be exploited, but I do think that we have a right to self-determination. I know this is a really difficult issue, and there's so many different what-ifs and this and that, but personally, you know, I do not want to be silenced, and I know that there are many families out there who are silenced. They are not able to access the court system to have the publication ban removed. The barriers are just impacting them, and they're not able to share their story, and that's contributing to their grief. However, I just noticed one of the tweets about should we have to suffer in the public eye of the media, because there is a stigma associated with having a child in care. I don't think anybody should be suffering, so I really hope that we can solve this.
Your question was if I were to die, or if any of us were to die, would I want the fact that I was in care and all my information released? No. But, because I'm a private person, but everyone has a different perspective. So, when I brought up earlier how some kids don't want their parents to have the right to, I wasn't referring to myself, but it's a different perspective to look at it, where they don't believe that they have that privilege. They see it as a privilege, because if they weren't in their life once, or if they didn't, like, I don't know, if they didn't participate while they were living, why should they participate to have closure when they're dead, is a way of looking at it as well. That's not how I look at it, because that's just not my way of looking at it. But I personally wouldn't want my information released, and I wouldn't want, like, people to be like, oh, Faven died, blah, 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 and she was in care. I just don't like the fact that we have the labeling of, like, a child dies. A child is a child. And I don't think that there should be any restrictions or any limitations if the child is in care or not. That's just my perspective. Like, I don't think that I don't know, like, that's just, I don't see the whole separation.
Who should be talking for you? Like, let's say we have a call. Who should be talking for you if you're dead? Who do you think should be telling me if I should release your information?
That's a personal question again, but who do I think that should have the right to say, Faven, this and that, should her information be released? It depends on who I said I would want to, like, you know how you have that permission thing? Do you want your information released to your parents? Do you want your information released to a friend, a family member, a sister, or something like that? So I think that the family ultimately has the right, but that depends on the circumstance, right? It's always the case. So if the child has involvement with the family, of course the family should have the right. If the child doesn't have involvement with the family, or if, because there are some children who don't even know who their parents are, and then I guess they're seen as children who existed and that no longer exist anymore, which is the saddest part.
I think, Monique, you wanted to add something, and then we'll go out into the audience.
I think a part of it as well is that a lot of children are in foster care, right? They reside in, like, I resided for 9 years, so I had the same foster parents for most of that time. They then took care of me. My mom lost the privilege of obviously taking care of me. So again, like, we are given consent forms to sign off, like, who would we like access to our information. So again, like, it'd be my sister, or at the time I had an aunt, and so they would have that information. But it's at, I think as well, depending on that their situation with their family in foster home or group home, I think that if that foster parent or parents or group home caretakers are then taking care of that child or youth, I think that they should also have even just a little bit of a choice, because they were then that parent, right? They then took care of that child or youth. They were part of their lives for X amount of months or years. So they help raise that person, right? So if they then lost them, that not only affects the parents, but also affects the people who take care of them, the people who are in care with them, their friends and everything else, right? That's something, so like if I were to have died in care, I wouldn't say that I was front page. No, definitely not. But maybe have it, obviously they are investigated, but make it public that it was investigated and these are the reasons why I died or so-and-so died. And how can we prevent this again, right? Like, we don't want young people or any people to die, right? And it's the same for me. Why just me? What if one of you had died? You weren't in care. You were in the system. What would you, right? You guys would have been public. Whether or not your parents, right? Some people would choose not to be public and other parents would have chosen. But it's that their parents have that choice. Why don't we? Why are we then just hidden, right? Why are we just erased, right? I don't think that it's fair that just because we are in care that we get that label. I don't think that it's fair that we have that label and that we are then hidden from the public, right? We are just as equal as everybody else in this room.
Thank you. Charlie?
Good morning. Billy Shibler from Manitoba. This is a very complex subject, as we can all see. On this Friday morning coming, we will have the release in Manitoba of a report that has been long awaited by the people of my province. It is in regards to a public inquiry that was done into a very tragic and violent death of a 5-year-old child, Phoenix Sinclair, who had been at times attached to the child welfare system. In Manitoba, our people are familiar with Phoenix Sinclair. We know Phoenix Sinclair. We know 2-year-old Gage Gamon. We know 4-year-old Venetia Adi. We know these children. Their photographs, their names are etched in our memories. Our province is going to be held highly and publicly accountable after an almost, over $9 million public inquiry that took almost 2 years to conclude. The recommendations that will come out of that report will be followed very closely by the public in our province. Those children had an identity, and people knew it. And people will know it and will remember those names. I was responsible in Manitoba to conduct those reviews into child deaths. And while those reports were not made public for the most part, the recommendations were, it was imperative for me in what I had understood as my responsibility to those children to ensure that the people that were reading those reports knew those children and knew their identity. And every one of those reports, wherever possible, had the photograph of that child and the name of that child clearly and boldly printed on the cover, because I was given the understanding that my responsibility was to honor the spirits of those children, and that people needed to know who those children were, that it was more than just words on a paper. This is a very emotional subject for me.
Thank you.
I've journeyed long on this. And while I appreciate very much what my learned friend shared in regards to media responsibility, I can tell you that my experience has been twofold. I have come across very many media people, both in my province and nationally, that have been very respectful of the sensitivities in regards to a death of a child. But I have also seen some terrible, sensationalistic, tabloid reporting that has been so damaging to the families and the siblings and the victims' connections, caregivers. workers that have been left behind. So I think we really, really, really need to be careful with this one. Thank you.
Good afternoon. I think it's afternoon now. My name is Lillian Shirt. I am 74 years old. I don't consider myself an elder, or I ever will. But I have some knowledge about the natural law that describes my people's history from way, 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 way back. A lot of you don't understand what natural law is for my people. When a child is born, one of them is, we take the placenta, we go bury it out in the mountains, we pray with it. Praying that that child will be blessed throughout its life in this world. The industrial road will be there. Education, work, home, family, love, spiritual foundation, first and foremost, to be strong. Those are our prayers. You violate that right away when you apprehend that child from the mother's arms. You violate that right. It's under this document here, United Nations Declarations of the Rights of Indigenous Peoples. In here, in page 22, all these acts that were passed, this is what governs us now. We go by this at the international level about our human rights. First and foremost, spiritual, physical, emotional, and mental. These four cycles in our lives, the spiritual foundation is what was taken away from us when we were in residential school, when the Treaty Acts were passed in 1885. We were stripped of our right to speak for ourselves, to run our own families, to be of prayerful people, the spiritual path. Our elders, our spiritual founders, our most sacred people were hung, 7 of them, in 1885, November 25, 1885. They predicted, before they got hung, is that there would be fences made. These are called the predictions. There would be fences made to circle my people. Men gana gusigatewa. That means there'll be invisible fences that will be made to corral you. You won't be of your own personal. You won't be able to think for yourself, to act for yourself. That is the legislation that was passed in 1885, the act that was passed in 1885. When you take that child from Treaty 6, number 7 or 8, you violate our treaty right. We didn't sign that treaty with you. No. We signed a treaty with the Queen. Your taxpayer dollars pay $41 million to keep her upkeep in the house, while many of these young mothers who can't even afford to pay their rent, because they don't have rent, they don't have food in their home, they don't have a phone, they don't have a car, they don't have work. How can you have work when you don't have a home? Under these employment acts, you need to have a home and an address in order to have a job, right? And education. You need to have a home, an address, and a phone in order to have education, right? Dollars? Yeah. Now, when you don't have those, and you have a child, who's going to be questioning about, somebody's going to be questioning you about that child, that because you don't have a home. They're going to apprehend your child. And this happened. For the 50 years I've volunteered in Edmonton, in the streets of our Edmonton, working with families that are Indigenous, that are homeless, in education and work and the industrial road, in the court system. I would say about 20 years ago at the courthouse, it used to be 2 pages of people that were going to be going to court, women who were going to go into court for their children. Now you have a whole wall that's all lit up. You've been there. You've seen that. The whole wall is all lit up with all Aboriginal kids who are going to be fostered in care. I don't know, you call it GST or GSP or something like that, children in care. Children are going to be adopted. It used to be where we had a say in the 60s and 70s, 1972, when Minister Lougheed asked us, what would you like to do for the children? In 1972, there was 4 laws that were passed, legislations that were passed in the legislature. One was for the housing, one was for the human rights. Our right to govern ourselves, our right to a home, education, dollars, and our right to raise our children in health and peace and harmony. The other one was the housing. Indian Affairs bought 127 homes in Edmonton so that we can go to school and go to work. And that's been privatized, and then we've lost those homes. Those people are making $1 million on that benefit we got from the Indian Affairs. The other one is the women. There was at one time, you speak about violence. At one time, if we called the city police, they wouldn't come to us because we were married. That law changed in 1972. We made that change. In 1972, if you were married to the man who was going to shoot you even and terrorizing your children, the police could not come to your home to protect you. I went through that. I went through all these issues that I'm talking about. I know about them because we worked with them in the streets of Edmonton. The other one is the violating of the spiritual foundation is when the child has passed on. We have, what I do today is I do end-of-life care. And then we bury under the natural law that little belly button we looked after, the placenta we looked after, the Indian name we looked after. Each child is given an Indian name, a spirit. How is that a European somewhere that's making a cash cow out of that child to pay for their mortgage going to respect that Indian name of that child? That name is taken from a bird, animal, the 4 elements, or the 4 elements of the universe. The Indian name is the most and foremost important one that carries you on into heaven when you pass on. That is the most spiritual violation. We don't have a religion. We don't have a church. Our whole domain, our whole church is the universe. We respect the universe, and it's called natural law. None of you have talked about actually why we're here. The very reason, and it's from the news media. Thank you for bringing that information out. Thank you. But I would like to see my own people, us Kukumak, Nukumak, us. We could think. We're blessed with a brain. We want to be there at that table there if there's any legislations to be passed. I know how to write. I know how to read. You know. We want to be there at that table. You're talking about our children. We want to be there. Us grandmas have had enough of tears, of pain and sorrow, being disrespected. It's a racial act that you've been doing. It's racist movement. You need to stop that. if you want to be accountable for your own life, when you stand before that great one, that when you die in heaven, when you go to heaven. Not all of you are going to go to heaven for that. Just kidding. Love you all. Thank you. But think of us.
Thank you, Lillian.
Oh, I did have some comments from earlier, but I think they're consistent with what we just heard as well, and certainly with the information that Samantha and Faven and Monique provided. And I think that your stories and again the comments that we just heard just emphasize the need, well, point out that different people have different ideas about privacy and about whether they want to be out there, whether they want their information out there, whether they are more private and they don't want to be discussed publicly. And I think that what we need to remember in drafting legislation and having laws is the importance of that choice and the importance for you to be able to make those decisions, you or your immediate family, rather than have a decision maker who is distanced from you. And again, that's what fundamentally privacy is supposed to be about. It's about making those decisions yourself. It's about self-determination and empowerment and having some control. So we need to make sure that that is built into the legislation and acknowledged and respected.
I would like to make a couple of comments, and I was really struck by your comments, Lillian, about natural law and about what led us all to be here. And it was really the power of the media to bring information to the public that drove us towards a roundtable. So for me, that's critically important. It tells me, it's an example of many ways that the media and the press provides a public service. My office, we rely on the media to tell the story when we have a story to tell. But I want to tell you about another story. I sometimes get calls from reporters about issues, and I got a call from a reporter one day. It was, in fact, a CBC reporter who said, I've got this 15-year-old girl here. She has a story that is an important story, but she doesn't need it told in the media. What she needs is an advocate. Can you find a way to help her? And we got her some help, but what it did for me was it really struck me that that's in fact the first time that I can remember where the reporter wasn't calling because of a story. They were calling because of a need, and recognized that the need wasn't for a story. It was for something else. And I have thought about that repeatedly since then, because I think it suggests that there can be different roles that we play depending upon the kind of information we receive and what we need to do about it. And I think that also adds to some of the complexity around publication bans. Because had that reporter only been interested in a story, had he not heard something more than that from that young person wouldn't have been connected to an advocate, and that young person's needs wouldn't have been met in the same way. And so I just raised that as an example of how those roles can sometimes shift, and it's really the focus on the young person that helps make those decisions and make those decisions central to what happens from there.
What I wanted to say was, I was listening very closely to our three young ladies, and it struck me quite strongly once again that there is no blanket rule for any situation. As we can see, we have three different people with three different views, and I think putting that into consideration when looking at the whole Publication Act, etc., might be a way to begin to look at it. A complete ban would not help the issue. There has to be something there that says if it's in the best interest, blah, blah, blah. But thinking of the children, what they would think. I mean, in medicine, we have all these advanced directories kind of thing whereby somebody can make a statement about what I would like done to me in this circumstance. You know, do I wish to be resuscitated, not resuscitated? Do I wish, you know, this family member to know about my condition or not? And sometimes, you know, people make very strong things like, I do not want my husband to know anything about what's going on. You know, we do that. But the point I'm making here is that those things do exist in other systems. And why can't it exist for children where there is a systematic attempt? Because you can get consent from a 5-year-old. If you talk to them in 5-year-old language, you can. It's just working with them to really get what they need in advance of an incident happening, the same way as we would look at it, you know, in advance of any other situation. It's been done in other situations. I don't see why it cannot be done here, where there is a relaxation of the publication ban with the caveat that, but before you receive any information, we have to know, one, if the child is alive, we need to go there and ask, do you want this published about you? But where the child has passed, that there should have been a process to try and understand what the child's wishes would have been. And that's just what I wondered about as a possible way forward.
I have a question for either Colleen or John. We've heard, I think, quite eloquently from the youth and some others about the need for choice as to whether personal information is disclosed in circumstance or not disclosed. And there's lots of complexity about who would make that choice. But from the media perspective, do you have a point of view? Should it be down to someone deciding yes or no individually, or do you have a broader context on that particular question?
Thank you. Referring back to what I addressed initially about this, this situation being the publication ban that we have right now being the exact opposite of what we advocate for, or I'm sorry, what we would support as a gallery, the colleagues that I represent, is to flip it around. And we just heard that there shouldn't be a blanket ban. Our argument is that there is right now. When it comes to who makes that choice, and we've heard a lot in the last day from the minister about allowing parents to make that determination about releasing the name and photograph of a child after death. And there are issues that need to be explored with that as well, because is it 2 parents or is it 1? And if it's only 1, which one? These are complex situations, as we all know. There are complex situations in these families. And so how is that going to be drafted if that is going to be one of the outcomes of this? And so what we support as a gallery, the colleagues of mine that do this work on a very regular basis, is to flip it around. If there needs to be a publication ban, prove it. Make the argument for it. Right now, it's the other way around. Everything is banned, and we have to approach court in order to get it released to us, or approach the director. Our argument is to flip it around, and so, and much as a system exists, I believe, in other provinces.
Just to, no, never mind.
Okay, sorry.
No, well, of course, I concur with John, but you brought up a very good point about the complexity of families. You're going to find all kinds of complexities when this starts to get investigated thoroughly. And people have said it's a complex issue. I think there's a better word for it, and I don't know what it is. But the fact that we're talking about it, and that we're hearing from youth and from Madam here, I think it's wonderful that this is now on the table, and let's see where it goes from here.
So Sorry, if I may, let's not get too Pollyanna about this as well, because the fact that we're discussing this right now is good. But in speaking to many of my colleagues, this wasn't discussed when this first went through. It wasn't discussed publicly in a very open manner. And so it's good that it's happening now. We would agree with you on that point. But this is a conversation that's long overdue.
I think that, of course, this is a really complex issue. I mean, I don't think that anybody should really have to be in the media front page, like be the subject of gossip, just like the Kardashians or something. You know, we need to have respect for the dead and for the families of the dead. And I really agree with what John was saying about, you know, it's complicated. There's two parents sometimes involved. You know, whose decision is it? But my question is, I mean, like, where are the people who have lost children? You know, like, where is their input in this conversation? And children who are still in care, who are still at risk. I mean, babies are really at risk. They can't quite talk yet. But teenagers are also very high risk too. You know, a lot of them end up committing suicide. There's a lot of mental health issues. But can we not ask their opinion? Can we not ask the families who have lost children already? They need to have input into this, and we should have more respect for the dead, and we should not just completely silence families. You know, we should give them autonomy and allow them to have a voice. I think this is a step in the right direction, but you know, we're not solving this today. I mean, like, you know, this is going to take a lot of work. This is going to take a lot of input from, I think, everybody, and we need to figure out how we can do what's in the best interest of these children, because they're the most important people.
Just very quickly to add to your point, I agree completely with where you were going with that. But also to add the wider family. So where are the grandparents in all of this? Where is the community? Where is the auntie who might have helped, you know, sort of hold things together when the child was there and all that? Perhaps they want their stories told too, because family, you know, it depends on how you look at family. You know, parents, grandparents, couple of cousins here and there, they're all family. And they're all upset by what's going on. And where do they come into this whole publication issue? I'm just throwing it out there. I don't necessarily have an answer.
Well, and one of the struggles I think about from an ethics point of view is that we have this notion of best interest. We don't really know what that means. And an important thing to talk about is not just the best interests of children, although that's critically important, but the best interests of this child. And we've heard very eloquently how each situation can be different. There are situations that lots of us would not be able to imagine. It's really important that we have a process that gets to honor the voices that we've all talked about that are important, that attends to the values of each individual and their families. We're really quite inured with the idea in North America that we are islands unto ourselves, that we have this right to self-determine and about ourselves only. And many cultures in the world, and Aboriginal cultures, as in my limited way of understanding, have a much more healthy sense of community, the spiritual life of the community in past generations and ongoing after someone dies, than maybe what I could call traditional or white-looking North American society would be like. We need to learn in a very different way about how this individual person is in the context of their community, in the context of their family, and in the context of, as Lillian has nicely stated, the notion of natural law and spiritual law. We don't understand that very well. And until we have those voices that many of you have talked about contributing to the conversation about how we can best formulate legislation and processes. Legislation is there for protection, but it's the processes, how we live that legislation. we will not be able to get this right for very many people. So I certainly appreciate the language that's been talked about today and the call for our ability to actually engage the right voices so that we can get this right. It will be difficult. There are so many things at stake and there are so many different views. The ability to have the flexibility to honor individual people and who they are in the totality of their personhood in their community is absolutely vital. So my call would not be for a prescriptive law, but a allowing law or a flexible law that gives us the ability to actually honor individuals, as people have talked about.
Going back on the process, I think it's very, very important. And we were hearing earlier the importance of the choice. When we go back to the extended family, though, that's where the processes will have to be very, very clear. Because on the field, the reality is that sometimes it goes very well because all next of kin are in agreement that information can be shared. But sometimes it's the sister that wants the brother not to know, or the daughter that wants the mother not to know, or the grandmother not to know. So we will need to have clarity to be able to do our work of sharing information to the right people according to the choice, if it was to be expressed. But if it was not to be expressed clearly enough, we'll need to have clarity in legislation, who has the right to the information, and if they don't agree with it being further disseminated, where do they can stop it and where they can't stop it. And I don't mind how it is decided, but we will need clarity, because I will need to know, can we talk to the grandmother if the mother do not want to? Can we talk to the mother if the child didn't want to? We will need more clarity.
I think part of it also comes into like what you were saying is that, like, again, like we said before, as a youth or a child that goes into care, we are given those consent forms on what we'd want released, to who we want it to be released, to our mom or dad or our aunt or uncle, grandparents, cousins, whoever it may be in our family or whoever is close to our family. We are given those consent forms to sign at every age. Of course, a toddler or a baby cannot sign that form, cannot give that information out. But even then, how long is that child in care? When they are able to make that decision, they should also be given that choice then, instead of forgotten about it, right? We, like, again, like I was given that consent form, we all were, or we should have been, right? We have that choice on who we want it given it to. So for you to know, I think that you should be able to have access even to that form to see what that child had wanted prior to their death, right? I think that all needs to be in perspective.
A question I'd like to throw open to everyone is, I'm hearing, and right from Jill's opening comments, about the decision around privacy or publication being rooted in principles. And you talked about consent, you talked about sort of a variation of informed consent, to my own language. Eric, you started to raise the idea that dignity in all of its meanings, in terms of personhood and identity and privacy, all wrapped up in that idea. So my question is, if we acknowledge there's something we need to fix, are we needing to identify a new or enhanced set of principles, or have we got the right principles and we don't have the right practice of applying them? Or do we need to do both?
Our tendency is to produce actions being good people that we think are good, and then maybe justifying it afterwards with one or two principles. Instead of looking at the group of principles, beliefs, values, history that underlie who we are as people. And so I think the important thing for us to do is to make sure that we have given voice to all the possible principles, and that will take a big sense of community engagement, a big process, to try to understand them, and then to have the debate about under what circumstances individual or groups of principles and values and beliefs apply to the particular circumstance. So what are the criteria around which we might say that this particular principle or value or belief supersedes another, because no principle always supersedes every other one all the time. And I think that's where the difficulty, the general language of ethics is a challenge, but where it can actually help us to get somewhere that we need.
I would just like to back up what you said. I think that's very true, and I think that is where we have sometimes gotten into trouble with our existing privacy laws. They are designed to be flexible, and they are designed to look at each circumstance. Certainly when cases come to our office, we're looking at all of the specific circumstances and weighing and balancing to arrive at a decision. The challenge when you write legislation that is flexible enough to accommodate different situations is that you lack certainty and clarity. And again, in my opening comments, and I hear this all the time, and I said this, that the laws as we have them, there's fear. There's fear about sharing information to help young people. There's fear about public disclosure of information for accountability purposes. Nobody knows quite what the legislation says, so there has to be, some sort of balance there, and the devil's in the details, how you get there and work that out. But balancing certainty with the flexibility that's required to be respectful of each individual's circumstances.
Any final comments from our group here?
You mentioned when we consider family, who are we considering here? What about the other youth in care? I mean, I know personally, in living in 4 different placements over 2 years, I've lived with like 100 other people, I can imagine. That's a lot of people that you've lived with, and that's not strangers, it's not acquaintances, you live with those people. So how do you think that the other youth in care feel about this, knowing that there's kids in care that die, and they suddenly become non-existent? We're not allowed to talk about them. Like, they're family too, but they're also disconnected and separated often. You start getting to know somebody and then you move on. And I don't want to get too far off the topic here, but I really think that it's important that we hear the voices of everybody, especially people in the community, families, youth. And I do empathize with how youth in care might be feeling if they're hearing about this right now, knowing that, if anything happens to them, they might lose their identity. Like, how do you feel like a human being? How do you feel like a person if you feel like you just can't exist because there's some publication ban saying that you don't exist, your story will not be shared, you will be forgotten? That's just, it's traumatizing, and I think something should be done.
Just another thing again, like, we are all equal, right? As a child or youth to any adult or any other child or youth who are not in care, right? We're supposed to be equal, right? We're supposed to have equal rights as a child or youth in care as opposed to someone who is not. So why is it, again, like, I think it needs to be looked at that, like, a child and youth is treated equally, whether they're in care or not in care, no matter what the case is, right? We want to prevent the death. We don't want it to happen. And so when it happens, again, like Samantha said, I grew up with several fostered other children and youth, and if one of them had died while I was in care and I couldn't speak about it, that would definitely change the way I heal, or vice versa, right? Like, we live with children of all ages and youth of all ages, as well as the foster families. They have their own children who are not in care. They cannot speak about us, and vice versa, right? Like, we can speak about them, but they can't speak about us. So I don't think that it's fair that we have that label on us and we live with people who do not have that label.
Thank you. So I would propose that we take a break for lunch. We can reconvene at 1:15, where we'll take this discussion out to everyone else and see if we can start to not just acknowledge the complexity, but start to look at some of the things we can do to move forward with it.